Hi guys, in today's video I'm going to be talking to you about non-fatal offences and I'm going to be discussing some of the issues that there are surrounding the Act. So most of non-fatal offences are defined in the Offences Against the Persons Act, which is dated 1861. So we've had this Act for over 100 years and there are quite a few issues with it. Now the Law Commission has been pushing for reform since the early 90s, but the government are yet to change the law. So there are three main issues that I'm going to talk to you about in this video. There are some more which you will explore in the extra resources that I'm going to provide. And these three main areas are the fact that the language is outdated, which is not surprising due to the age of the Act, that there is some inconsistency with the sentencing within this Act and the different types of offences, and also that there needs some clarification with some of what these terms mean and what some of these offences mean. So I'm going to start off with talking about the language being outdated. So like I said, this Act dates over 100 years, okay? So some of the terms used aren't now frequently used in modern society. So two main terms that you could discuss in an essay are words grievous, and also you could talk about malicious. Okay, now because these words aren't used in modern times anymore, it's led to judges having to interpret them in cases to clarify what these words mean to jurors. Now DPP v Smith has interpreted the word grievous to mean really serious harm. Okay, so when we're looking at grievous bodily harm, which is section 20 and section 18 of the Offences Against the Persons Act, so the most serious types of non-fatal offences, Smith's told us it means really serious harm. Okay, so it gives us a little bit of clarification. It's not just going to be, a scratch, okay, a punch, a bruise. It's got to be something that's really serious. However, that still doesn't give a lot to the definition because that's going to be open to interpretation. So different jurors might have different ideas of what really serious harm is depending on their age, background, gender, life, social class. So for example, a woman may view injuries as really serious harm, whereas a man may not. Okay, don't know if that's a bit of a stereotypical thing to say and not totally accurate, but it's true. A woman could view injuries more serious. It could be people from different social classes. So I don't know, someone who's from an upper class or middle class may think that some injuries are really serious harm, whereas someone from a lower class may not, if they've been around some violence or seen some sort of injuries. So that could be an issue, that we have some clarification on what these old terms mean. However, it is still quite up to the person's interpretation. But you could argue that that's a good thing. Is that not the point of having juries? Is their role not to interpret the law and base their decision on the facts of the case? So if they're all sitting there and they come to a unanimous decision that in that case, based on those facts, they think those injuries are really serious, is that not okay? Should the law be so stringent that we've got to follow it to the letter? We've also got the word malicious, and this has led to some discussion as well. So with section 20, the defendant must maliciously wound or inflict GBH. And the word malicious is referring to the mens rea here, okay? Now, when I think about the word malicious, and I think a lot of people would also think this too, I think about someone doing something intentionally. So I would think if someone had malicious thoughts that they would be perhaps a little vindictive and they do have bad intentions. So there is some intention there. And I think that's because this word malicious in a modern society has taken a new sort of meaning. Whereas years and years ago, malicious might not have had this terminology and this meaning. So it is a little misleading there. Okay, so when we think about malicious, it can be intention, however, it can also be recklessness. So if someone takes an unjustified risk and they cause a wound or inflict GBH, then they can also be guilty of the section 20 offence, okay, as recklessness is sufficient. So I think that term could be clearer. though the judge will point this out to a jury, so you could argue, is it really an issue? Yes, it might not be clear reading it first off, but if the judge is going to clarify that malicious can include recklessness, is there an issue? And the second main issue that I'm going to discuss are the inconsistencies with the sentencing within the Act. So, when we come up from assault and battery, into the Offences Against the Persons Act, we have actual bodily harm, which is the next most serious offence. And then up from actual bodily harm, we have grievous bodily harm, section 20. So we've got these two offences here. Now, section 47, which is actual bodily harm, there's no set definition in the statute. It is an assault or battery occasioning actual bodily harm. So it could be a threat, a gesture, if V apprehends immediate unlawful violence, which is an assault, and that causes an injury, or it could be the application of unlawful force, which is the actus reus of battery, if it leads to actual bodily harm, So ABH is more concerned with the injury, It's one of those consequence crimes, So there needs to be a certain injury to be guilty of actual bodily harm. So what does that actually mean then? Well, this has led to the courts developing the law in this area, and the case of Miller tells us that ABH could be anything which interferes with the health and comfort of the victim, So this could be, for example, loss of consciousness. It could be extensive or multiple bruising. It could be small cuts which require stitches, psychiatric injury beyond fear and panic, temporary loss of sensory functioning. It could be minor fractures, a broken nose, which sometimes students get confused with. So a lot of students think that a broken nose is actually grievous bodily harm, when it's not, unless it's a really serious break and the bones are sticking out the nose, which would be really nasty. Broken bones that do not break the skin, because remember, to be guilty of section 20, there needs to be a wound, which Eisenhower tells us is a break in the continuity of the skin, both layers, or GBH, which is really serious harm. So we've got section 47 with all of these types of injuries, but it's anything that's going to interfere with the health and comfort of the victim. Now, we're not talking about a little scratch. That's not going to interfere with your health and comfort, is it? It hurts you at the time, but, you get on with it. It's not going to be a little bruise. You're going to get on with that. It's going to be the extensive bruising, the cuts which require some stitches, but they don't pierce both layers of the skin, minor fractures, broken nose, Whereas to be guilty of section 20, there needs to be a wound, or the defendant has to inflict really serious harm, So for these type of injuries, you're looking at broken bones that pierce through the skin, both layers. You could be looking at a stab wound, much more serious injuries here. And the CPS give guidelines again on what injuries constitute grievous bodily harm. So have a little look over the poster that I've provided, have a look at more examples of them. But the point I'm trying to make is grievous bodily harm is a step up from ABH, It is more serious injuries. So you might be surprised to learn that both actual bodily harm and grievous bodily harm, section 20, have the same maximum sentence of 5 years imprisonment. Yeah, that's confusing, isn't it? Why have we got section 20 in the Act? Why have we got a more serious offence you could be charged with if the punishment is going to be the same? It doesn't really make sense. So that needs to be looked at, and really they should be increasing the prison sentence for grievous bodily harm. So the final issue that I'm going to talk to you about, it's some of the wording and the confusing between the non-fatal offences if you were the defendant or a layperson, or maybe even if you're on the jury. So when you learn about non-fatal offences, we separate the terms of assault and battery, and we talk about them as two different types of offences. However, they can be grouped together as common assault. And that's what the CPS do, what the police do, and you will, hear on crime programmes. So there's also So there's sometimes a little bit of confusion when people learn that you can be guilty of an assault without actually physically touching anyone. If we go back to the actus reus of assault, it is for the victim to apprehend immediate unlawful violence. So they've got a fear that they're going to be battered, okay, that there is a risk of battery, but there doesn't need to be an actual battery, okay? So if they're fearful that at any moment that person is going to inflict unlawful force, then that is enough for an assault if the person, the defendant, also has the necessary mens rea, which can be through recklessness. So you could have a person who's joking around, okay, in their head, but if the victim actually thinks they're going to, be hurt immediately, then that can be enough for an assault. And there is obviously confusion with that due to battery and assault being grouped as common assault. Okay, so should that be changed? Should there be some clarification within the law to point out, there doesn't have to be a physical touching. If the victim is scared, that is enough. Okay. However, you could argue, well, that's a solicitor's job to clarify. Okay. A solicitor will explain the law to their client, and should really Parliament have to write statutes in layman's terms? And that means in the reasonable man, the everyday person's terms, so that they understand. Or should they be writing the law in such a way that solicitors and judges will understand, and then judges can explain the law to jurors, solicitors can explain the law to their clients? Okay, should we really be needing to dumb down the law so that if anybody picked up the act, they could understand what it means? And you could go back and forth with that. The term battery as well, that's also a little bit misleading, because if you think of the word battered, as people use it in everyday language, I'm going to batter you, and oh, you're getting battered. You think about somebody getting a beating, okay, not just the slightest touch. And remember, Collins v. Wilcock tells us that a battery can be the slightest touch, okay? So when they arrest a prostitute and pull her arm up her back, that is enough for a battery, okay? If you shoved someone, that could be enough for a battery, all right? Also, the fact that a battery doesn't have to be physically touching the skin. So R.V. Thomas tells us that a battery can occur through touching clothing, so grabbing someone's coat, grabbing someone's top. Is that very clear? The fact that a battery can be committed through an omission. So you don't even have to physically touch someone. If you owe someone a duty of care and they are injured due to you neglecting that duty of care, then that can be a battery. So in the case of Santa Bermudez, when the police officer asks the defendant who they are arresting, have you got anything in your pockets that is going to injure me? And he says no, when he has a needle inside his pocket, and the police officer then begins to search the defendant and pricks her finger on this needle. That was classed as a battery, because the defendant owed the police officer a duty of care by putting her in that dangerous position. So remember, if you create a dangerous situation, you have a duty to stop that situation. And he could have easily done that by saying, actually, hold on, I have a needle in my pocket, so be very careful when you go in there. Okay? You don't even physically need to do anything. It doesn't need to be an act. It can be an indirect act. Okay? It can also be an omission. So those are the three main issues that I'm going to discuss with you today. There are some other issues you can talk about. For example, if Section 18 has a discretionary life sentence, you could discuss that issue and other things which are on the Law Commission report. Okay, I hope that was helpful. Thank you.